Hi, everyone, and welcome to the newest edition of AI and the Future of Law. I'm your co-host, Jen Leonard, founder of Creative Lawyers, here as always with the wonderful Bridget McCormack, president and CEO of the American Arbitration Association. We are here, as we are every episode, to talk about all the wonderful and exciting things happening in the land of artificial intelligence and the future of law. And as part of our new partnership with the Practicing Law Institute, this season, we have been thrilled to be joined by some guest experts who are doing really cool work in the space of AI. And this episode, we're joined by Phillip Young and Daniel Long from Garfield Law. We had the chance to talk about Garfield Law in an earlier episode that sort of caught fire online among our audience. So we wanted to have Daniel and Phillip join us in studio to share about their project. Phillip is an ex-city commercial litigator and is now in a named solicitor role. And he reviews all platform outputs from Garfield Law, and they'll talk all about the work that Garfield Law does. Daniel Long is a quantum physicist turned AI entrepreneur, my old job, and he is a lead architect of the underlying system and former data scientist who works at Garfield Law. So welcome to both of you to the podcast. And Bridget, hi, it's great to see you.
Yeah, you too. Happy Friday. And I'm so excited to get to talk to you, Phillip and Daniel. It was really fun to talk about you, and I bet it'll be even more fun to talk to you. So thanks so much for joining us. This is going to be a really fun conversation this morning.
Yeah, thank you very much. And thank you for the invitation to join you.
So every episode, we like to start before we talk about the law. We like to hear how you are using AI in your personal lives to do something unique and interesting and magical to inspire other people to try it as well. We call this our AI Aha segment. So Phillip, maybe we could talk and start with you. What have you been using AI to do recently?
I've found that I'm now using consumer grade LLMs to sort of act as a sort of a personal sort of lifestyle assistant. And the best example I can give you of this is sort of those little niggling things that otherwise would be a pain in the neck, but an LLM can answer really quickly. And so I don't know how it is in America, but somehow British smoke alarms always decide to go off by accident at 2 a.m. in the morning. It's never sort of during a normal time. It's only ever 2 a.m. And that's the last time where of the day where you want to try and find the manual to work out how to reset them. And so I found last week when that happened and you wake up at 2 a.m., you're not even sure who you are, let alone what's going on, that you just sort of type into the LLM, here's a photo of the smoke alarm. It's going off. It shouldn't be. How do I fix this? Then off goes the LLM. It comes back with the instruction manual. It gives you detailed instructions about how to reset the darn thing. You don't have to hunt in the folders behind me for the instruction manual. When you get it done, you go back to bed. So yes, I mean, that's been my latest LLM making my life nicer experience.
Love that.
Jen and I use it for tech support all the time. And I call that tech support because I am not a quantum physicist. So when I need to fix a smoke alarm, I think I need tech support. But yeah, it does make life easier in that way. How about you, Daniel?
Yeah, how does a quantum physicist use it?
Not for quantum physics. No, I find, I mean, people presume sort of quantum physics to be complicated, but I find that then I have these sort of really basic other questions. Like I've been for years trying to understand music theory, trying to get better at guitar. And I've got musician friends and they'll explain it to me like 1-2 times and it never quite makes sense. So I've taken to just the most simple dumb questions, building up the complexity to Claude I use most of the time. And finally, things are making sense to me that took years to make sense otherwise. So that's me with the guitar and Claude trying to make some music.
Do you have your guitar this morning, just in case we want to hear how it's going, or not really?
I do have it, but I mean, I think recently with Garfield, I've been pretty busy. So I think my practicing has been a bit lax.
Fair. Well, we're excited to have you all because you have launched a pretty interesting new legal practice, Garfield AI. Why don't you tell us a little bit about what Garfield is, what it does, and our listeners know a little bit, but we probably have new listeners since then, and they heard it from us, and we bet you could do better. So maybe, Phillip, you can give us an intro to Garfield.
Yeah, sure. I mean, maybe the way to start the intro is just to explain where the idea comes from. So, as you ladies have mentioned, for many years I was big ticket commercial litigator and arbitration lawyer in the City of London. And from time to time, my brother-in-law, who lovely guy called Andy, he's a plumber up near a city in England called Sheffield. He would have the classic problem that small business people have, which is that he just wouldn't be paid. And it wasn't usually because the debtor was insolvent, or it wasn't because the debtor had a genuine grievance with the service provision. It was just that debtors know that some businesses don't have the time to chase their debts and find even the small claims court in England, which is supposed to be a simplified system, intimidating. So, being the good brother-in-law that I was, I would step in and help him collect these debts and help him go through the court system. But sadly, in our country, not everyone has a brother-in-law who's a litigation partner. And so the problem is widespread. And I always thought to myself, this is ridiculous. There has to be a better solution. And then when ChatGPT 4 came out in sort of March, April 2023, I thought to myself, one could build something with this that could provide a solution. And I think part of the reason behind that was I'm sort of 50% lawyer and 50% giant nerd. And I've always played with computers since I was knee high to a grasshopper. And I just sort of got the computer side of it. I got the law side of it. And I thought, yeah, you could build something that would handle this sort of case, because these cases tend to be fact heavy. They don't tend to be legally complicated. It tends to be primarily process. And it tends to be a sequence of what Dan, I think, beautifully refers to as relatively closed problem spaces. And that's an ideal challenge for an AI to tackle. So that's where the idea of Garfield came from. And then I'll hand over to Dan in a second to talk a bit about the tech side of things. But I found Dan, and then between the two of us over the last 2 years, plus the team we built this product called Garfield that now seeks to do what a good English law firm would do to pursue a small debt claim, all the way up to the edge of trial itself. And it is regulated as though it is another English law firm. So it's essentially an English law firm that provides services through AI, which makes it a first in our jurisdiction and I believe the world. So that's a quick introduction to where Garfield came from and what it does. I'll just hand over to Dan for a few seconds to talk a bit about the tech side of things and maybe how he's found it having to work with a boring lawyer.
Well, I'd say Philip described, we said at first closed problem space, but the schematic that Philip gave me when we first started of a small debt claim in the UK was anything but closed and simple. It was, I don't know how many boxes and how many steps there was. Since then, we've managed to sort of try to shrink things down. But inherently, there's a lot of different pathways. Luckily, they sort of close in often, which is, I guess, what we mean by closed problem space. But yeah, on the tech side of it, we first started just initially trying to see, could we do all of the sort of individual stages we wanted to do? We'll probably discuss this later, but the big fears are hallucination, a big fears are, taking a user into a direction that they don't want to go down. So could we design the product from the ground up in a way that wouldn't lead a user into those issues, was the initial questions. And pretty quickly, we could see that this was going to be possible. And because the process that exists already is so time heavy, we thought that anything that can streamline a lot of those steps is going to be really valuable. So yeah, on the tech side, I mean, Philip described himself as a former city litigator. He does have a lot of coding experience, maybe not in environment, but he's certainly dabbled a lot. So a lot of the early codes, and still to this day, when he's got time, Philip will join in and roll up his sleeves and write bits and pieces.
I should say Dan is being really kind there, and Dan and the rest of the professional programmers, when they look at my code, they're always really kind about it, but I can tell deep down on some level they're slightly dying, but they are able to then turn it into professional grade code.
Well, the thing we joke, which will make sense to a legal audience, is like legal documents are all these sort of numbered, bulleted paragraphs. And as a non-lawyer, I'd never seen that before. I certainly don't like that. And as a software engineer, you certainly don't write code in that way. So we're always sort of trying to remove lines in Philip's code that is written a bit like a statement of case rather than a script.
And how did you connect with your small businesses? How did you get the word out about what you were doing? Were you contacting them when they were already in court? Were you sort of like advertising to them in advance of being there? How did you spread the word?
So we had some early adopters lined up in advance of getting regulatory approval. I have to say that the regulatory approval took quite some time, and rightly so, because we were asking our regulator to do something that had never been done before, and so they spent a lot of time looking at with us at all the ethical and regulatory issues that it gave rise to, and I think it was probably helpful that one of my sort of smaller areas of practice when I was in practice was regulatory law and professional discipline. So I know the regulatory code really well, and I understand the law in that field. And so I'd already thought about a lot of the issues in building and designing the architecture with Dan. But that took 8 months in total. And so that gave us quite a lot of time to sort of line up some early adopters. And then what we were anticipating, because like all lawyers, I'm very cautious and careful. I always sort of stop and think before I do anything, even if it's just going and making myself a sandwich. And I wanted to do a very sort of quiet stealth rollout over 6 months without the world at large knowing that we existed, so that we could get some claims go quite a long way through the court platform and see how they did at each stage. But I'm afraid the world had better ideas than me, and somehow the Financial Times found out about us, and the next thing that we knew, we were in the Financial Times, and from that point on, Dan and my life became a lot more hectic because suddenly there were journalists queuing up to talk to us, and from that point on, obviously, interest became a lot greater and a lot more users applied to join the platform.
I probably should know this, but in the United States, most small and medium businesses, even like larger medium businesses, just don't have in-house legal help, and they largely can't afford legal help. So your brother-in-law, the plumber, has you, so he could come to you. Is it the case that most small and medium businesses try to navigate the legal process on their own? Do they give up? Do you have any sense of that? Like what the market typically does with problems like these?
It's exactly the same in England and Wales. So if you're an S or an M in SME, then you're unlikely to have a general counsel. You're unlikely to have much, if any, of a legal budget, and you would only either DIY the process if you could bear to do that and you didn't feel daunted by it, or for larger value debts, you would then instruct external counsel. But certainly for small debts where the sum's up to £10,000, it's uneconomic usually to instruct an external law firm in England. And that's no criticism of any external law firm. It's just that it has historically been a manual process. It's therefore very time intensive. It's therefore naturally costly. And although in England we have a different rule than you guys have about cost recovery. So in England, our general rule is that the loser pays the winning side's legal costs. That rule doesn't apply to small claims. And so that makes it even more uneconomic to instruct an external law firm. And the result of that is that, depending on which survey you read, there's anywhere each year between £6 billion up to north of £23 billion of debt that isn't collected, that is small debt in England. And obviously, for a big economy, that's a huge sum of money, and it's really inefficient.
So let me ask you a follow-up question now on the regulatory process. I did not know that you were an expert in regulation. That does help. But I was still, when I read this story for the first time, I was just really taken aback that you could have your regulator approve this early. It felt in the United States, I don't know of a single jurisdiction that's ready to approve a solution like this, even though I think we have a similar problem. And the small claims process is similar. It's usually only factual disputes, right? And those are disputes that you could imagine an LLM being trained to handle quite well, especially if you do some reinforcement learning around the different stages of the process. But I don't know a single U.S. jurisdiction where I could imagine this happening soon. So, what are the cultural differences between US and UK regulation, or what was your secret sauce, or why do you think you were able to manage the regulatory path so well?
So I think there's a series of factors. So the first factor is that our regulator in England, the SRA, I should just say for American lawyers who've had no contact with the English legal profession, we have a split legal profession. So we have barristers who are specialist court advocates, and we have solicitors who do essentially everything else in a contentious case. And I know from my history that until an unfortunate disagreement in 1775, I think America had the same basic system until people couldn't come to the Inns of Court in London and become barristers, unfortunately. But so we have this split legal profession, and I'm a solicitor, so my regulator is the SRA. I think the factors are that first, the SRA has a public duty to promote access to justice, and they take that really seriously. And they've been well aware for a long time that there is a real problem around small claims. And it's not just a problem of people not being able to access the court. It's also a problem of people that do access the court who are litigants in person, present badly prepared cases to overworked judges, take up a lot of judicial time, don't necessarily get the quality of justice they deserve, and it makes a system that's already overburdened even harder to operate. So the problem is on two levels. And so the SRA is always looking for solutions to things like that. Secondly, there's been a lot of policy concern in England by the regulator, from the senior judiciary, and from the government about people turning to unregulated products, particularly LLMs and consumer grade like ChatGPT, to help them navigate through the court system. And if that's the only possible product that someone's got, then they're going to turn to it. And the problem with that is that they get answers that are, perhaps without disrespect to those products, inaccurate, possibly misleading, and possibly worse. And in a litigation context, that's incredibly dangerous because of the rules about contempt and all of those, all of the hierarchy of rules about not misleading the court. And I think everyone's been very concerned about that and keen to sort of get to a world where there's regulated products available to people. I think the third factor is that the SRA felt this was coming. It was only a matter of when. And when we presented ourselves to them initially, they looked quite closely at us as people, and they felt that we were a good team. We obviously understood what we were doing. We have the right experience and the right support. And they felt, I think, if they were going to back anyone, they were going to back us to begin with. And it's not like they've sort of just given us regulatory approval and let us go off into the blue sunset and do whatever we want. I mean, they're being very sensible, and we're doing 3 monthly catch-ups with them. We're trying, to the extent we can, consistent with our duties of client confidentiality and things like that, to give them know-how and feedback. Because I think if you're the first, you owe a sort of public good citizen duty to try and help the powers that be build out the regulatory framework to deal with the further series of products that people are clearly going to build. Because whilst Dan is a genius, I'm not. And if I can think of this, plenty of other lawyers will think of similar products. And I've already been shown a bunch of products, a bit like Garfield, being built in England. So I know there are plenty of other ones coming. And so the regulator's been thinking about all of that too. And so that's really the factors that have led to this. I wouldn't say, without any disrespect to my profession, I wouldn't say that we're an unusually creative legal profession in England any more than any other jurisdiction. And if anything, I'd say most English people look to Americans and always think you guys are 5 years ahead of us anyway. So it's quite a surprise to hear that you might not be ahead of us on this one for a change. I don't know, Dan, did you have any thoughts to add from a sort of technical perspective?
I think something in the dialogue with the SRA that's interesting is what we can do in terms of tracking how users are getting on with the system and keeping an eye on that. So that's probably pretty challenging generally in a law firm when a lot of your information is all in unstructured formats. Whereas, we have everything very tracked, with everything as discretized as possible in terms of where a user is and what routes they go down. So it's probably relatively unusual for them, the sort of reports that we produce for them in terms of how users are funneling through the system. We're constantly analyzing whenever users are messaging our system. We're constantly even using LLMs themselves to determine, did something go wrong? What did they want to happen? How should the system work better? That's why it becomes, you don't get that much sleep, because there's constantly feedback being fired off to me and Philip and the rest of the team at all hours. But we then try to condense that down, and we'd like to be able to produce some interesting stats about how people are using us, what's working, what isn't, in a way that's quite challenging if you don't have a pure AI system.
And I think as well, there's an architectural point, and this goes back to understanding the regulatory framework we operate in. So from day one, I was very conscious of the fact that if we're going to provide a regulated legal service, and you have to be regulated to do what we do, you can't just conduct litigation in England without regulation, without being regulated, then you have to take into account all of your obligations. You have to take into account your, it's called the Hamid obligation, so the obligation you owe to a court as a lawyer. You have to take into account client confidentiality, you have to deal with conflicts of interest, all of the ethical stuff that will be very well known to your listeners in America, and it's basically the same in England. And so we built the architecture of the software product with all of that firmly in mind from day one. And I think the SRA took a lot of comfort from that, because they could see that this wasn't the sort of product where, and again, no disrespect to tech bros, where a bunch of tech bros had just built something and thrown it at the law and hoped it worked. This was very much a product designed and built by a lawyer and a technologist working together to build something that is both accountable and responsible. And ultimately, they also took some comfort from the fact that we call it the COLP in England. It's a compliance officer of legal practice. And that's me at Garfield AI as a law firm. And so I'm accountable to my regulator as I'm accountable to the judiciary for the functioning of Garfield and its compliance with the ethical rules. And I think accountability and responsibility are the two themes. If you're building a product like this, you've just got to have in the forefront of your mind all the way through.
Philip, you mentioned the word platform earlier. As a user, are you engaging with the court system exclusively through a platform? How does that work with small claims court where you are?
So our small claims court has the almost unique distinction in England of having an API, an application programming interface, which means that users that are signed up to that can interact in terms of exchanging data with the court programmatically. And that's what Garfield does. Garfield is essentially integrated into the county court service. So Garfield can send claim forms to the court, other documents to the court. It can receive data back from the court. And I think that's very much going to be the future of law firms, frankly. But it makes things a lot quicker and easier. And in fact, in England, we're actually right on the verge of phasing out paper and pen. It's going to be in the next month or two, you're not going to be able to send a paper claim form to the court anymore and get a claim issued, which is, when I think about when I started the 1990s as a lawyer, that's almost unthinkable. That's where we've reached.
Could you resolve a dispute where you are without going to the courthouse?
You could if you didn't need to go in front of a judge. So imagine that you're using Garfield and you've issued a claim form because you've sent the pre-action letters and you've not had a satisfactory response. Then imagine in response to the claim form, there's a possible range of options. You might get paid, in which case, great, the claim is over. You might receive no response, in which case you apply for default judgment, and that's, again, a programmatic process that Garfield will do for you. It might be you receive an admission, which normally comes with a request for time and indulgence, in which case Garfield helps you then go through the process of resolving that. Or it might be you receive a defense and perhaps even a defense and counterclaim, in which case you're going to a small claim trial, which is not a very grand thing. It's a 1 hour in front of a district judge in a county court. But if you go down that track, then Garfield holds your hand down that. And there's a compulsory mediation on that track, and Garfield will help you attend the mediation, which is by telephone. And if you settle, then you settle and the case is over. So Garfield deals with all of those possible pathways that a claim could go down.
Philip, you mentioned that some of the things that are happening with the API and certainly with AI would have been unthinkable in the 90s. How are you thinking about the next decade or two? What do you view the future of legal services in an AI-infused world?
Yeah, I mean, I've got thoughts on this, particularly based on the last 2 years of everything that Dan and I and the team have done with Garfield. So I think, so in order to sort of tell you where I think we're going to, I think I need to sort of say where I think we came from. And so when I joined the profession in the 1990s here in England, all English law firms looked pretty much the same. The only difference between them was really one of scale. Some were quite small and high street firms, some were giant city firms. And they all basically, there was an office or offices, and it was always a case that the bits the clients saw were a lot nicer looking than the bits the poor lawyers and everyone else had to work in. There would always be some elderly people who were the partners who in the 1990s were, I'm sorry to say, overwhelmingly male and of a certain sort of class. And then there were younger people who were proper gender balance, who were the young lawyers who coming into the profession like myself. And then there was sort of a great strata of middle-aged ladies who kept the whole thing afloat. And they were the secretarial and support staff. And if it hadn't been for them, every law firm in England would have collapsed. So, you know, the old joke, you need sort of 10 people with their feet on the ground to keep one person with their head in the air. And that was a law firm. And there was a bunch of law books, and you'd have a court clerk, and that was your law firm. Amazingly, where we're going to end up in, I think, in the next 10 years is a sort of highly integrated type of business, which fundamentally exchanges data a lot more swiftly with all of the parties it has to deal with. So if you look at something like Garfield, and this is, I think, applicable primarily to smaller claims, but you can generalize to bigger cases and transactional work. So Garfield's integrated with a court service and exchanges data programmatically with a court service. And that's only going to increase, particularly as our government is going to build more APIs into more areas of our court service. So there's going to be one for bigger value civil claims. There's going to be one for family. There's going to be one for crime. All of that's coming. And it might be then the arbitration community have to start doing something similar with the big arbitration bodies, who knows. We are integrated with Companies House, which is our companies register here in England. So, for example, a user who wants to bring a debt claim against a corporate debtor, Garfield goes automatically to Companies House, checks out the status of the debtor. Are they solvent? Are they insolvent? Where are they? It pulls their latest accounts. If any are filed, it gives a view on the solvency to help the debtor know, to help the user know instantly whether it's worth pursuing that party anymore, whether they're wasting their time and money. We're integrated with various other services as well, inevitably. We're going to integrate with our land registry, which has got obvious ramifications for enforcement of judgments, and various other services. So, you know, fairly shortly, we're going to roll out a service, and I don't mind telling you this because it's coming in only a couple of months, where Garfield can do things like send automated SMS messages and make automated telephone calls, which, I mean, we'll control that so that it can't become a nuisance or anything like that. But you could see how you're going to end up with a law firm that has all of these automatic integrations that saves a lot of time and trouble, and will also then exchange data a lot more effectively with the law firms. So the English court system is trying to promote a common data standard, and I think that will drive a lot of this. Because when I think back to practice, one of the things that used to really annoy me was service of documents. And trying to get documents to another law firm, sometimes you had to kill trees to do it. Sometimes you had to serve at silly hours and no one was available. Sometimes you were trying to email ludicrously large PDFs on email. I think all of that's going to go, and it's just going to become a case of sort of almost a common data room where you can just exchange documents and upload them and generate bundles, and the court can see that in real time, so that if you've got a hearing coming up and the judge is pre-reading for the case, the documents are just appearing on his system or her system, and you're just going to have a lot more integration in the way that law firms interact with the universe around them. So one thing I didn't mention is another integration we built is Garfield integrates with our users' accounts platforms. So, you know, you can pull invoices, unpaid invoices and data straight. The user can pull it straight from their own accounts platform and put it straight on the platform. And again, that's another big time saving. And I think, so this is a future of law firms. I think all of these sort of integrations being built in, and a lot of the sort of the movement of documents and stuff around becoming a lot swifter and a lot more effective.
Something we joke about internally is that, you know, if you found the secret of the universe, it would probably be in a JSON format. And that's a sort of nerdier joke, but that's the data structure that, you know, most software uses. And trying to populate PDFs, trying to, you know, go to XML and these other older formats can be incredibly frustrating sometimes. My dream is that someday everything will just be JSON documents being flown around, shared schemas, and super simple, hopefully.
Oh, same. I mean,
I want that. I want that future right now. I was going to ask what your view is of what that will mean for the human lawyers that can, connect, that can have a practice where they're not spending time on the busy work and the maybe frustrating work of, finding the right documents and connecting them to the places they need to be connected to. Do you think there's going to be a need for more lawyers because more disputes will be able to be, or not only disputes, but more value will be able to be created by lawyers? Or do you think it might be a time for folks who are considering law school to think about being a quantum physicist instead?
or musicians?
So I might express a view on that, and Dan may have his own sort of view as well. So I'm an AI optimist as far as the law is concerned, and whenever I speak at conferences, I always tell the conference I think there's going to be a need for a lot more lawyers. And it's interesting, if the conference is full of lawyers, they're sort of happy smiles, but if it's full of non-lawyers, everyone looks really miserable for some reason. Goodness knows why. I mean, we're a wonderful profession, but yeah, I mean, the problem we have in England, and I imagine it's a problem in every jurisdiction in the world, is that there is a huge strata of work that is uneconomic for lawyers to do at the moment. And I think what will happen is that because the main reasons for that are the sort of the low value adding but very time intensive tasks needed to progress those sort of instructions, whether they're transactional or contentious, although as that work is going to be dealt with by technology, suddenly those sorts of transactions or litigation cases are going to be economic to do and therefore going to be pursued. And lawyers are going to be engaged to do them. And in a litigation context, of course, if a claimant decides to bring a claim that otherwise they wouldn't have done, there's going to be work for the defendant side as well, isn't there? So I think that there's going to be an awful lot more work for lawyers coming out of this. And I think as well that the good news is all that work that none of us went into the law to do, but we were presented with as junior lawyers, where someone said, oh, here's a room full of documents. Can you do a due diligence exercise, or can you do a big discovery exercise? And part of you internally just died, but you were a young lawyer, so you did it because you had to sort of earn your flying hours. I think a lot of that will go, and you'll move on to, even as a junior lawyer, you'll be doing higher level skills at a much earlier stage. And the example I give in England is I say the training of lawyers in England is very different at a small firm than a big firm. So if you're a trainee solicitor at a small firm, you're thrown in the deep end from day one, and you're expected to do higher level things like manage clients, evolve strategy of cases, come up with the best legal argument. Whereas at a really big firm, you're basically used as a document monkey, and you're put in a big room and told to read a lot of documents. And I think even big firms are going to end up sort of adopting the small firm training model as a consequence of this technology. And I think they've got no choice. I think they're going to be forced to by their client base. But even 2 years into this, lots of English suppliers of work to the big law firms, so general counsels of departments of big companies, they are insisting that the external law firms take up AI and take it up aggressively to drive down the legal spend that these huge companies have got. And so I think it's going to be there is no choice here. It's just going to happen.
My naive non-legal background is the sort of techno-optimist view, where we can move to a future where, civil disputes and maybe also criminal disputes, sometimes you're not held down by the sort of mundane paperwork filling stages, and instead these trials happen a lot more quickly, and then appeals can happen much more quickly, and that could mean that the whole economy massively benefits, where a legal dispute could be resolved in a matter of like a month or two. And it means, the judgment of the justice being delivered would still be given as much thought and attention, but all of the parts that can be compressed, that don't really require judgment, like the form filling and the sort of, those could be massively accelerated. So I feel hopefully quite optimistic that could be, we would see economies that do embrace regulation and embrace AI could massively benefit. But yeah, that's the techno-optimist view in me that's coming out with that.
I think I'm both of those. I think I'm an optimist for the legal profession and an optimist for the economy generally. So I tend to agree with both of those. I think right now lawyers are hunting in 10% of the potential legal market because, like Phillip said, so much of it is uneconomic and they can't make ends meet. But when all of that changes, there's the rest of the iceberg under the ocean, and there's an awful lot of work to be done that will give, I think, lawyers more satisfying practices and grow the economy. So I think I agree with all of that. I want to backtrack. I have so many things I want to talk about, and I don't know how much time we have left, but I at least want to talk about how you all solved for hallucinations. In the United States, and I think in many jurisdictions, we see a hallucinated case citation story every day. Now there are judges getting into the action. I think they must have felt left out. And that's kind of all we're talking about over here. And I don't know if maybe in England you're more careful and nobody ever includes hallucinated case citations or quotes in their legal briefings. But how did you solve for that with Garfield? Can you talk a little bit about why the regulator was convinced they didn't have to worry about hallucinations with your product?
Yeah, I can definitely assure you that people in England are no more careful than anywhere else in the world. I'm sure if they were, then the administrations of Lord North and stuff wouldn't have lost America a few hundred years ago. That was a serious error on their part. Anyway, yes. So it's something I've been very conscious of, and so has Dan since the day we started, because it was obvious hallucinations were a serious issue even 2 years ago when this journey was beginning. And so we designed our product very much with this in mind. And we built in a whole series of safeguards and guardrails, some of which I'll let Dan talk about. But I will just mention one thing that I think is, personally, I find really interesting, and it's an architectural thing. So because of the need to ensure that the risk of hallucinations was reduced to the bare minimum, we didn't just build an LLM only product. And so in that sense, the press in describing us as an AI company is slightly doing us a disservice, because the product we built is a hybrid. It has a deterministic expert system and a probabilistic LLM based series of systems. And the expert system being deterministic, we allow to be in charge, and that then controls the universe of possible things that the LLM can or might do. And it's a bit, if you're not a techie person, one way of describing it rather inexactly is it's a bit like having the result of my years of practice being in charge of the LLMs and constraining them about what they can and can't do, meaning that helps to minimize the risk of hallucinations. So that's one of the things. Another thing is that we try to sort of adopt the best practice that a law firm should adopt. And so we tell the user at every stage what Garfield has understood from the documents that have been uploaded, from the information it's been given. So the user can always see what the platform understands and what the next options are. And it's not autonomous. The user has to approve each action before it takes it. And that is exactly analogous to the way, for example, my former law firm that I co-founded used to operate, where whenever we drafted something for a client, we would run it past the client for approval before it went anywhere. At the end of the day, the facts come from the client. The argument and the presentation comes from the lawyer. And so you always need the client to check the facts, or I think you should do. And Garfield takes exactly the same approach. And if the user spots that something has been misunderstood, just as something might be understood between a human lawyer and a human client, then the user can correct Garfield. And so that's a very important safeguard as well. And I think the third relevant factor is, depending on what statistics you look at on the internet, obviously hallucinations are an inherent thing in LLMs, And as a consequence, all of the big boys in the space have poured huge sums of money into research and trying to mitigate them. And so if you look at the statistics, as the models are getting better and better, the incidence of hallucinations does seem to be dropping dramatically. And certainly from the SRA's perspective, the point they made to me was, if your product is operating at least the level of a reasonably competent human, then that's already more than good enough. And eventually, with technological progress, you'll get to a point where you'll be acting at the level of a superhuman, and that's clearly way better. so you can see those are the sort of features, some of the thinking that's gone into this. And I have to say that I've also seen some products, I won't mention who's building them, in the last few weeks, that are specifically designed to fix hallucinations in legal documents and legal products. And so those are coming. Those are going to be on the market in the next year to 2 years. And so this is a very well-known problem, and an awful lot of thought and work is being put into making sure it's manageable. I imagine Dan's got his own thoughts on this topic, because it's fundamentally a technological one.
Yeah, no, I agree with all of those. I think the thing I'd add is that the way I think about it with hallucinations, and I think it's fairly shared, this thing we're thinking about it, is if you stood over someone and you said, right now, write me a contract, or right now, write me, fill in this claim form perfectly, they would probably get it wrong, and they would make mistakes in places. And that's true for humans, and it's true for LLMs. LLMs have a additional bias where they want to please you far more than probably the average human does. So that only exacerbates the problem. But in other domains, the way this is resolved, so for example, in software engineering, you're not directly pasting the first output of an LLM into your code base and then deploying it and then watching as the errors flood in. Instead, you are using agentic systems, which will write some code or write some tests, will iterate the tests or iterate the code to match the tests, and then add new tests as it goes. And we'll sort of all of these traditional software ideas of traffic light development, things like this, can be applied with LLMs. And because software engineering is such a space where you have such verifiable outputs of the code, it lends itself very nicely to this. And I think the challenge in other domains is then to try to pose those problems in such a way that you can have verifiable outputs, or at least broken down outputs. So in the case of Garfield, we don't take in a user's message and just directly output a response at all. In fact, there's many LLMs that are constantly in parallel determining how different parts of the claim should be modified based on the user's instructions. And then, like Phillip said, all of those modifications are then passed back to the user and said, look, you gave us this invoice. We saw this company number there, and the wording looked like it was your company number, so we stated it as such. And there will occasionally be mistakes, but it's down to us to articulate it as clearly as possible to the user what we've understood. And then it also allows us to, once we've extracted the information in that way, we have the expert system, which is, like Phillip said, a sort of codified version of his brain that sets in certain rules. So all of the fundamental rules that might invalidate a small claim, like we have a £10,000 limit on a small claim, but there's also statute limitations, things like this that we've got to look out for. And because we're not using LLM to judge, does this claim look valid to us? We're actually just using traditional, basically if-else statements throughout our code base to make sure that that conditions are met. So by converting the problem into more of a software problem, where you have verifiable data, you can then make sure that we're not hallucinating outputs. And then that, coupled with the fact that we are trying to be as transparent to the user as possible, making their lives easier, but also not allowing them to just sort of take their hands off the wheel and assume that everything will be correct.
And I think there's an analogy there, isn't there, for the way that law firms operate, because a review, correction, iteration process is the way law firms operate. So when I think about documents I've drafted in the past, whether they're witness statements or skeleton arguments, what you guys would call briefs, or other documents, you might do a first draft. And if you're a junior lawyer, it might go up to a more senior lawyer. They might review, amend it. You might then re-amend your document. It might go to a partner. They might change it again. and the finished product that goes to the court or the client or the other law firms is often somewhat different than the very first draft. And it's a sort of similar analogy with the way that I think AI-based legal products would be built, so that it goes through a process of review and iteration and polishing before the final product is presented or goes somewhere. And that's every lawyer in practice anywhere in the world, I think, understands the key importance of that.
Something else as well actually just occurred to me that I forgot to mention was, but it's quite an exciting area, and I know Phillip enjoys talking about it as well. It's the way that Garfield tests itself. So we spent maybe, I don't know, 30% of our time, 40% of our time sort of building the actual product itself, but majority of our time is spent really testing the product. And that can be traditional software tests that just chuck in an output, chuck in an input, expect an output, but actually went a step further, and James on the team was really keen on this and has put lots of time into improving it, where we'll have Garfield talk to itself and pretend to be a user that has a small debt claim, or maybe doesn't have a small debt claim, and then we can look at how well does Garfield respond to that user and correctly classify them, and does it hit any issues? Because, like I said earlier, we started with this very complicated schematic. We tried to simplify it, but inherently the process is very branching in a small debt claim. So having a system that can navigate all of that and not make mistakes, we realized we could actually use an LLM to simulate the system and do then multiple runs in parallel that allow us to really quickly flag issues.
It's amazing what you built, and I wish we had another hour to learn even more about it, but we're coming to the end of our time with you. So maybe we could wrap up with one last question. Hopefully we end on a positive note, but I don't know. But how have other solicitors and barristers responded to what you're doing? Have you become leaders? Are other people inspired to follow and think differently about how legal services are delivered?
Yeah, so I was expecting a sort of lukewarm welcome at best, and possibly even a slightly negative welcome, because the profession has always been small c conservative in England. But actually, I've been really surprised at how very welcomed this has been. And I think, and when I look at the users we've got on our platform so far, the sizable chunk of them are law firms, either pursuing their own debts or using Garfield to pursue their clients' debts in a way that's more economic for them, gives them more margin, and allows them to scale quicker as a law firm. And I think it's because everyone in the profession can see this technology is going to be useful, and they want it to be done right, because it is coming, love it or hate it. And the fact that, again, it's been built by a team of a lawyer and a technologist, and the SRA has regulated it, and everything's been done sort of according with the approach you should take if you're being responsible, I think it's made people feel a lot more comfortable. And I think the profession also sees that there was a real problem here that Garfield's trying to fix for the benefit of the community. And one thing about lawyers worldwide I've always found is that people become lawyers because they generally care about justice. I've not ever met any lawyer who didn't become a lawyer because they care about justice, and they care about people being able to access the courts if they need to. And lawyers do get concerned when there are justice gaps. And I think that is part of the reason why lawyers have said this thing is a good thing, and we're in favor of it. So yes, it's been welcomed very positively, and not just by the profession, also by our judiciary. So we're very fortunate in England that our senior judiciary at the moment, the Lady Chief Justice, the Deputy Head of Civil Litigation, and the Master of the Rolls, all are very sort of forward-thinking, as are, in fairness, the members of our Supreme Court and also the Court of Appeal. And they're very much in favour of AI being used to make the justice system quicker and more efficient and provide a better quality of justice, as Dan was talking about earlier. And so they have sort of cautiously welcomed this as a development as well, without, of course, in any way endorsing it, because they're judges and they can't endorse a private product. But there's a sort of groundswell of warm feelings towards it that we've been very grateful for.
That's wonderful. And, I certainly don't have the expertise that either of you have, and this is maybe an oversimplification, but I think Bridget would share the takeaway that throughout our conversations with great people doing innovative things, the through line is mindset around what's possible and the reason that we're all part of the profession and what we're trying to do. And that definitely comes through in your work. And we're just huge fans of what you're doing and can't wait to see more. So thank you for spending your time with us today and sharing your experience. And thanks to everybody out there for tuning in. And we'll look forward to seeing you on the next edition of AI and the Future of Law. Until then, take care and be well.